Come on. Wait. Hey, good morning, good morning, good morning. We are going to jump right over to court as they are getting started. So we're going to jump right over there now. Here we go. This is Judge McBurney's courtroom. Here we go. And this is a situation that Yak Gotti got himself into while in lockup. Give me a 1 in the chat if you can hear the video, please. Oh my goodness. Okay, I didn't know. Let me get this. I don't know what was going on there. Okay, let me see what's going on there. Let me try it like this. Okay, now let me know. 1 or 2. 1 if there's sound, 2 if there's not. Still no sound. What? Okay. All right. Let me see. They haven't gotten to Yak yet. So see what's going on here. Okay, let's try this. Okay, sound. Yeah, that's what I did was a reset. Let me know if you have sound. Yay. Okay, good. There's Max Sharp.
Do you have one of the? You're just a hanger on.
I'm a hanger.
That's what I thought. Okay.
Yeah.
You got nothing to do these days.
That's right. No, I'm actually next door. I'm next door, but yes, I'm looking for things to do.
Okay. I got some
Good to
things.
see you guys.
Yeah, let me know. Could do some trials next year. Yeah.
This might have been after your time. Did you ever go to University of South Carolina for the Trial Advocacy Center over there as a AUSA?
Yeah, a lot. That was where all our trainings were.
Right, right.
Yeah.
I went to school there, and last week, Victoria, she was a mock judge. They have the district court judges go down and help train. So I got to go back down there, and that was always on campus when I was there.
Yeah.
Towards the end of my time there, it was on campus, but I never really took note of what it was. It was just some fancy building that I knew nothing about.
Nice. Yeah.
Yeah. So
Yeah, because the residences are there and there's a cafeteria and then all the classrooms.
Well, I heard the residences aren't that great. They put us up in a hotel right next to it called the Graduate. It was a good time. So I got to take Hollis down and show them where I went to school and
Good.
everything.
Excellent.
So,
Your family event.
yep.
We've got Baker. Okay. Mr. Tevis, you ready to go? Ms. Clark, we're gonna do Mr. Robinson Baker. That's who we got. I'm just saying. All right, Ms. Rivers, are you ready? Okay, we're going on the record in 24 PI 008168. It's State versus Tyreek Robinson Baker. Good morning, Mr. Robinson Baker. I'm Judge McBurney. I don't think we've met before, but your case has been assigned to me just for bond purposes. The state may at some point indict you for what you were arrested for. That'll be randomly assigned to some judge. It might come to me. Chances are it will go to a different judge. But as long as there is a question about bond in your case, then Mr. Tevis or Mr. Wolf, one of the lawyers working on your case, will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf?
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is a good candidate for bond and what that bond should look like.
Judge, you of all people are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building. that I want to argue against the backdrop of that. So first of all, everybody's famous case in Georgia, Ayala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303, Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm, and detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail, because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done, the state will rely heavily on the facts because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation and also worked for FedEx making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control.
While we're on a different case, do you guys hear an echo?
Parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because the media case did not let us in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle, not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies.
Okay.
On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. You know, I know your background, having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice is to set a high bond, which in all honesty is, you know, enriching the bonding company, but I don't think that that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bonds?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
and
that.
that's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so I think there was one that was a
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but
Yeah.
the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a
Let me unmute. There we go. Okay, I'm sorry. We're going over to the Atlanta News First stream. Because they're skipping over from courtroom to courtroom, and that's a lot easier for them to do than me.
Cobb County for possession of marijuana with the intent to distribute.
There we go.
And possession of a firearm.
All right, guys. Because it's going from like 5 different courtrooms today. So here we go. Yeah, I know. I didn't have a sound. It wouldn't let me unmute for some reason. All right, here we go.
And possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have one prior misdemeanor conviction in 2022 in Cobb County for a non-criminal offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't gonna be calling on you, today, I didn't think, but, do you know if there is a warrant in the system for Mr. Robinson Baker, for his probation at Cobb in light of?
It is up all the way. I wonder if we shouldn't go back to the original
Can't
feed.
hear you, it's odd, you're not muted, but can't hear you. Other people can hear you, that's peculiar. Some of my staff said they could hear you, but it's not coming into the courtroom. I don't know what that deal is.
Wow, I can't hear them at all. Maybe we'll go back. I can't hear this at all. If you can hear it, let me know, but I can't hear them at all. Do y'all want to go back to the original feed? I kind of do.
He is not yet. He does have a warrant. Okay, thank you. That's what I needed to know. Appreciate it. Ms. Clark.
Good morning, Your Honor.
Good morning.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself
Original
in.
feed, yeah, I kind of agree.
And after a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So that is.
Mr. Tevis said something about Mr. Wolf getting Mr.
Okay, we'll go back to the original feed. Oh yeah, this one.
We're here for bond.
My understanding
And
is
to address that,
yeah,
we're looking at the Ayala
then we'll
factors.
jump over to
Your Honor,
the courtroom where
The
Shannon is
state
getting,
wants to bring the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that, bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge. Felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. There's a young lady, Kim Yee, who actually was a friend of the victim's at one point. She actually ended up coming over to the place where the incident location, where the assault happened. So these people know each other, and there is an intent to intimidate the witnesses. Ms. Head, the victim in this case, says she fears for her life, and that she does not wish for him to have bond. She is actually has provided a statement to our victim witness advocate that she'll read for us. But this is a serious capital felony crime, despite counsel opposite's suggestion. It is the nature of the crime does warrant a no bond status. And that's what the state is asking for. We believe it's appropriate in this case because the defendant is currently on probation. He has shown that he does not comply with court rules as he has violated bond orders when he was actually on probation. And as I said, he's on probation for the drug marijuana with intent to distribute and the firearm charge out of Cobb County. I think that he has a high risk of intimidating witnesses because of the fact that there is a friendship between the female that was assaulted. I think the roommate or something was also, he knows the defendant. So there are a lot of people that the defendant would have access to. And so for those reasons, I think the bond should be denied.
All right, thank you, Ms. Clark. So, Mr. Tevis, you had asked to have rebuttal time. You certainly can have that. I'd ask you to include in there what more you can add, because I believe it was your client's father was sort of raising his hand on this issue of the delayed turn-in.
Yes.
Getting more mysterious to me. And it's not dispositive here.
Sure.
I think the Cobb situation is for a temporary ruling that I'm going to make, but but if you could clear up as best you're able, knowing that you're parachuting in as well,
Sure.
what your understanding is with, hey, you should turn yourself in. I'm not turning myself in. However that played out.
Sure. My understanding is that the police were talking with Mr. Baker Robinson. They wanted him to come in, as I said before, make statements, talk to them. He was waiting to hire counsel. He also had some private family medical issue he was trying not to go in about. I've checked our records. Mr. Wolf was hired at the beginning of November. I know that they were talking and meeting with him in October. And so the last couple months were, you know, Mr. Wolf was talking to police about arranging a turn-in at the jail, which they did, and they surrendered him.
So ultimately, there may well have been before, I'm gonna call it your firms, but before the collective legal involvement of you and Mr. Wolf and others, who knows, there may have been some back and forth, and,
Sure.
and the police may have perceived that your client was reluctant.
Right.
It's not like he's under an obligation, but
Of
he
course.
was reluctant. But in the end, the way that your client went into custody is that a lawyer escorted him to the county jail or wherever.
Correct. He was surrendered to Fulton County Jail.
Got it. And the state's perspective is, gosh, that took a whole lot longer than it should have if this is someone who was coming in to say, hey, let's clear this up.
Sure.
And I understand that, and there, that's a reasonable perspective. Anything else you wanted to add?
Sure. I could guess that probably part of the delay could have also been, if we're guessing, that police were just kind of lazy in this case. I mean, you can call someone and say they have to turn themselves in, but in reading the preliminary transcript, interestingly, that the state brought up, hey, you know, well, let me back up on that. The buzzwords that I'm hearing from the state that I usually hear are, I think he's a danger to the community. We believe, the state always believes that, they always think that, and they always oppose bond. I mean, the credibility in the building, there aren't even cases where they consent to bond at first appearance, not even just serious violent felonies. And the state is correct that the court can and should consider the severity of the offense when setting bond conditions and the bond amount. But to say that the severity of the offense disqualifies from some bond is in direct contravention of Supreme Court precedent, Georgia statute, U.S. Constitution. That's just not the case. Iowa is a murder case. That's where we get all these good languages and everybody quotes it when in fact it's actually codified in the statute. So the charge itself is not dispositive. With respect to he knows people, so we think he's a danger, both of those witnesses testified for the defense at the preliminary hearing, contrary to what the victim alleged. They were both present. The victim, they said, called us and said, hey, are we drinking tonight? Can I come over? She showed up with an open bottle. She was pouring out, taking multiple shots, all of those things. That is not evidence that he is a danger in any way, shape, or form. Both of those witnesses testified that they were there, they didn't hear anything, they saw them together, she was cuddling in bed with him, all these things. So at the outset, even though the offense looks serious, this, you know, there are various flavors of what this charge could be. Georgia has no degrees. You know, something that's ultra serious, violent, stranger on stranger is the same thing as people were drinking and they wake up and don't remember what happened. But that is not what was happening here. Both of those people that the state cited testified, were called by the defense under oath and directly contradicted what the alleged victim in this case said. So as far as the severity of the offense, the charge is very serious. As far as the strength of the case, we would contend.
Okay, guys, so they are waiting till the end for Yak Gotti. So they are getting ready to go live in Judge Whitaker's courtroom with several YSL defendants combating things that happened while they were in jail and different plea bargains and whatnot. If they go live in Judge Whitaker's courtroom first, we're going to go over there. Okay, just letting you know.
It's all the statutory factors. And again, the strength of the state's case at a fully drawn out preliminary hearing with an officer and witnesses was more favorable to the defendant.
Okay. Well, it wasn't, I guess, so favorable to the defendant. Judge Brooks still found probable cause to bind it over.
Judge, that's such a low standard.
But it's not that she said, I'm dismissing this charge.
Right.
Okay. All right. Is it Baker Robinson or Robinson Baker? I apologize if I was reading off the calendar I had. How do you say your last name?
Robinson Baker.
I got it right. Good. Mr. Robinson Baker, I'm going to leave you in a no bond status for just one reason, and it's a reason that can be addressed. You're on first offender probation out of Cobb. That's a delicate situation for you. This has come up while you're on first offender probation. Cobb has issued a warrant saying we need to see Mr. Robinson Baker to talk about what was going on in May of this year while he was on first offender probation for the marijuana and gun case. And I want to get you there so that can be addressed. Should that be addressed, and the only thing left holding you in custody is this no bond situation, we'll reconvene and we'll have this conversation again. Your lawyers will have a little bit more time. They might be able to produce a couple of these witnesses that they were talking about. And your situation, I've heard about the stability of your work and your household situation and all that. I won't need to hear that again. But what has come up most prominently is that you actually have a warrant, and I need to make sure you get to Cobb. And so I'll do that. You and a lawyer in Cobb will figure out what the consequences are, if any, for having been arrested in this situation on your first offender probation. And once that's been resolved, you come back here and we'll revisit this question of bond, and there won't be that cloud of, wait a minute, I could give you a $1 bond right now and you don't get out. You would go straight to Cobb. And I want to have that dealt with, and then that'll be off the ledger and we'll figure out what kind of bond, if any, makes sense in your case. Any questions about that?
No, sir.
Okay, Mr. Tevis, anything else on behalf of Mr. Robinson Baker?
Judge, just questioning the mechanics of how we're effectuating getting to Cobb. This would just be some kind of transport order, because he'll have to be released from this hold to get to Cobb.
Right, we'll work with Cobb on that so that then there's a hold put back in place. But we've done this before where someone goes to a neighboring jurisdiction. If it was Pennsylvania, I wouldn't be comfortable that we necessarily get them back, but it's an adjacent county. And so I'll work on the logistics of getting Mr. Robinson Baker there. And then I know you or Mr. Wolf or someone will let us know, hey, that's been resolved and he's back in Fulton. We need to address this again. Okay, very well. Ms. Clark, anything else?
No, Your Honor.
All right, thank you. Do we have an update?
Yes, Your Honor, update on the defendant cases for this morning. I have been able to get in contact with the other two attorneys who should be here for their clients. That's Mr. Pizzoli.
Okay.
He's presently in 2B with Judge Brooks doing preliminary hearings. Said he'll be up here as soon as he gets a free moment.
Okay, so he does want to go forward on his cases.
My understanding is that Mr. Pizzoli said he is ready for Hutchison, McCaslin, and Drinkard.
Caslin, now Drinkard, okay, great.
And
Does he have a client where he's saying sort of like your client, we're not doing it today?
yes, that would be for Mighton or as well as Alvin Powell, position 5.
Okay, so Ruben Mighton, we will defer to another day. And you said Alvin Powell, number 5?
Yes, same house.
Defer, got it. And then you said there was a third attorney.
Yes, one more, Jessica Jones, Attorney Jones, has Daryl Williams as position 1. She also, she's not ready, but she would try to.
There's a young lady back there who says she represents Daryl Williams. That was the name, I still didn't get it. She was way in the back.
Okay, Mr. Williams hired prior to them.
Okay, and did Ms. Jones have anyone else, or that was it? So Hutchison is Cazzoli, and he'll be here. Kuykendall, we don't know. McCaslin is Cazzoli, and he'll be here. Alvin Powell, we're deferring. Drinkard is Cazzoli, and he'll be here. Mighton, we've taken care of. You're Roderick Powell. And then we don't know about Beatty, but that may also be the young lady.
Beatty, yes, I know the Beatty is hired by the council. I don't know if that attorney's here.
Okay,
And I can also say that Kuykendall is a co-defendant in the castle, so she would be
a conflict defender.
conflict attorney. Well, I don't know if they got those.
Yeah, maybe not. So I'll at least let Ms. Kuykendall know we're not ignoring bond. We just, ma'am, are you ready to go on Daryl Williams? And did you say you also have Mr. Beatty? No, just, oh, you had Carl Washington. Got it. So you've been retained by Mr. Williams or his family?
I am doing this hearing
pro bono. Okay.
I filed a limited extra appearance for the purpose of bond.
Just for bond. Okay, got it. Thank you. What do you want to do? So we still don't have candidate. He's not up yet. Okay, so if we got Williams, why don't we knock that out? And then do we have, who else do we have up? So McCaslin will be able to do, both those, just the lawyer's not here, so we should leave them up. That's it? Okay, then why don't we bring Daryl Williams out, at least make progress. Uh-oh. Number 5. Number 8. Number 9. Yeah, but we don't do anything until someone reaches out. We don't have to proactive do anything. And then number 3 is a conflict defender case. So yeah, we can do that today. If she gets brought over, I'll let them know that what the situation is. Co-defendant number 4 as Cazzoli, and Cazzoli will be here. He'll be here later. You bet. All right, Ms. Rivers, are you ready? Yes. Okay, this is 24 PI 008200, State versus Daryl Williams. Good morning, Mr. Williams. How you doing? I'm okay. I'm Judge McBurney. I don't think we've met before, but we are going to talk about bond in your case. That's all we're doing today, just bond. And as long as there are bond issues in your case before it's indicted, that'll be in front of me. Once it's indicted, it's going to be randomly assigned. Could be me, it could be a different judge. We'll see what the state's doing with the indictment. I need your lawyer to announce her appearance so we get that on the record. And spell your name now that you're closer to a microphone.
Last name is YSL, IASIELLO.
Iasello, Ms. Iasello, thank you for being here for purposes of bond. Mr. Abate, are you handling this? Okay. Mr. Williams, you're charged with murder. You were originally charged with aggravated assault, and Mr. Clark passed away, so that was upgraded to murder. And I'm going to hear from Ms. Iasello why you should get a bond and in what amount. Then I'm going to hear from Mr. Abate about what the state thinks about bond. Let me pause for 1 minute. Ms. Clark, you were going to give me a victim impact statement, but when we have another hearing on Mr. Robinson Baker, make sure you do that. All right. Ms. Iasello, when you're ready. I think it's easier for Ms. Rivers to hear you if you do that. Thank you.
Good morning, Your Honor. Thank you for the opportunity to present this bond argument on behalf of Mr. Daryl Eric Williams, a man who stands before this court accused of a serious charge, murder. While the charge is significant, Mr. Williams is presumed innocent, and the purpose of bond is not to punish, but to ensure his appearance in court and protect the community. We respectfully submit that Mr. Williams is not a flight risk, is not a danger to the community, and is not a risk of committing new offenses or obstructing justice. Under Ayala, these 4 factors guide the court's decision on bond, and the facts of Mr. Williams' case support the granting of bond. In addition, I must bring the court's attention to Mr. Williams' significant and urgent medical concerns. Mr. Williams suffers from chronic kidney disease, is a kidney transplant recipient, is diabetic, and also suffers from neuropathy. These conditions require regular medical care, specialized medication, and monitoring that the Fulton County Jail is ill-equipped to provide. Denying him bond under these circumstances would expose him to substantial and unnecessary risk to his health. Lastly, it is critical for the court to know that Mr. Williams is the person who called 911 during the incident that led to his arrest. This act of seeking help does not align with the actions of someone trying to flee, evade, or obstruct justice. Due to a miscommunication with responding officers, Mr. Williams was charged. We are confident that as the facts unfold, the charges will be reconsidered, but in the meantime, we ask that the court grant him a bond so he can receive the medical care he urgently requires. The first Ayala factor asks whether Mr. Williams poses a risk of flight. The evidence clearly shows that he does not. Mr. Williams was the 911 caller and not a fleeing suspect. The most compelling evidence that Mr. Williams is not a flight risk is the fact that he is the person who called 911 and was not fleeing the scene, hiding, or attempting to avoid law enforcement. Instead, he actively sought help and remained present as officers arrived. As I stated, Mr. Williams' health condition makes it impossible for him to flee. He is a kidney transplant recipient and requires ongoing medical care, including strict medication schedules, metformin for his diabetes, and treatment for neuropathy. Any interruption to his medical regime could have catastrophic effects on his health. He has every reason to stay near his medical providers and avoid life-threatening risks of being on the run. Mr. Williams is deeply rooted in this community. He's the father of 4 children, 2 adult daughters, and 2 young boys. He volunteers with food distribution programs to give back to those who have less than him. His friends care for him so deeply that they reached out to me when they were unable to find him around Thanksgiving and subsequently located him on the inmate roster at the Fulton County Jail. I agreed to handle this hearing pro bono because I was moved by the love and concern of his friends who were desperate to help a man they described as thoughtful, generous, and kind. Mr. Williams has no history of failing to appear for court proceedings. He has shown compliance with all legal obligations and has no pattern of attempting to evade responsibility. The second Ayala factor asks whether Mr. Williams poses a danger to the community. Here, there's no credible evidence to support such a finding. Mr. Williams does not have a serious prior history of violence or any criminal history involving firearms or weapons. The court is not being asked to evaluate a person with a pattern of dangerous behavior. It's also worth noting that Mr. Williams is 61 years old and does not have a history of weapons charges. Mr. Williams' role as the person who called 911 is critical to this analysis. His actions show that he sought help, not harm. The fact that the charges rose from a miscommunication with responding officers should be carefully considered. If the court has concerns about community safety, Mr. Williams is willing to submit to restrictive bond conditions, including curfews or electronic monitoring and pretrial check-ins. As far as the third Ayala factor, risk of committing new offenses, Mr. Williams does not have a pattern of repeated offenses. His record shows that he has been a law-abiding member of the community. He does have a pending battery charge from July, but as that case unfolds, it will be clear that he was defending himself from attack. Mr. Williams' primary focus is his health. Managing kidney disease, diabetes, and neuropathy leaves little room for anything else. His medical condition creates a natural structure in his life that drastically reduces the likelihood of reoffending. If there's any doubt, like I said, he is willing to submit to restrictive bond conditions. And there's no indication that Mr. Williams would interfere with the administration of justice. He has no history of obstructing justice, tampering with witnesses, or evading legal obligations. And it bears repeating that he is the one who actively invited law enforcement to the scene and was not attempting to flee. And again, I would emphasize Mr. Williams' urgent and unique health needs, which the Fulton County Jail, frankly, does not have the capacity to address or provide the level of care that he requires. And therefore, I would suggest that denying bond in this case would prove to be life-threatening for Mr. Williams. We request a reasonable bond that is aligned with Mr. Williams' financial means. He is on a fixed income from disability and faces eviction soon based on the fact that he's been incarcerated for a month and has fallen behind on his rent during that time. I'd ask the court to consider a bond not to exceed $25,000. I recognize that the charge is very serious, but he does have very limited financial means, and we would be amenable to any restrictive conditions the court sees fit to impose. In conclusion, I would submit that the 4 Ayala factors weigh in favor of granting Mr. Williams a bond. He is not a flight risk. He is not a threat to the community. He has no risk of reoffending, and his medical needs create an urgent and compelling reason for his release. For these reasons, I respectfully ask that Mr. Williams be granted a bond. Thank you.
We'll have one question, and then there may be follow-up from you after we hear from the state. Is it your understanding of the situation that Mr. Williams was on the outside allegedly shooting in, or he was on the inside allegedly shooting out? If you know anything about the situation.
So my understanding of the situation is that Mr. Williams was in his home and heard shots outside his house and called 911 from the inside of his residence.
Okay. All right. Thank you.
Good morning, Judge.
Good morning.
The state would respectfully request you deny defense counsel's motion for bond for several reasons. The first being that the defendant does have 3 prior felony convictions, making him an A and C recidivist, in the sense that if convicted after trial, he'd be facing a mandatory life without the possibility of parole sentence. Furthermore, the state would submit to the court that the defendant is a risk of flight due to the strength of the case, in that Mr. Williams is seen on the ring camera waving a gun around after he shoots it through the door at the victim, who was inside of his home, who was struck in the face and ultimately dies.
So that was what I was asking Ms. YSL about. Mr. Clark is the decedent.
Yes, Your Honor.
Mr. Clark is in his home, or he is in Mr. Williams's home?
Mr. Clark is in his home, and
Meaning Mr. Clark's home.
Mr. Clark's home, yes.
And what you say that the ring cam video would show is that Mr. Williams would be outside the door, not of Mr. Williams's home, but outside of Mr. Clark's home.
That is correct.
And shoots into Mr. Clark's home.
That is correct.
Okay.
And actually shoots through the door and strikes Mr. Clark on the left side of his head. Ultimately, police are called and medical attention is attempted, but about 20 days later, he does succumb to his injuries due to being shot in the head. So I would submit to the court that he is a threat or danger to the people in the community in it, as he shot Mr. Clark through his own door, unarmed at the time, and posing no threat to the defendant, excuse me.
Ms. Ayciello indicated that Mr. Williams was the one who called the police and that he stayed on scene. Is that your understanding of the facts?
He is one of 3 people who called the police. He is actually the 3rd individual who called the police. The first 2 described that Mr. Williams was outside of the doors of not only their apartments, it's a 4-unit apartment building or home. And he was—
Is Mr. Williams one of the 4 occupants?
That is correct, Your Honor.
Okay, so he's around his own space, may not have been his door, but it wasn't that he lived across town and came to this place.
Correct.
Okay.
Outside of their doors, screaming threats at all parties who were around and living in the apartment building. So 2 individuals called, 2 females called 911 indicating that, and that they saw Mr. Williams outside their doors and the door of Mr. Clark waving the firearm, and then heard a single shot. Mr. Williams did then call 911 and was incoherent, I guess is the best way to put it. He was under the influence of something would be what the state would submit to the court, and he indicated that someone had just shot his brother. And I can clearly state to the court that Mr. Clark is not Mr. Williams' brother. And he did remain on scene. Upon the officers arriving, he did admit to shooting Mr. Clark through the door. So I can agree with defense counsel as it relates to that. So based on all the factors, Your Honor, and all the totality of the circumstances, the state would submit to the court that at this time, Mr. Williams is not a good candidate for bond and should remain in the custody of the Fulton County Jail.
Do you have any information, I don't know that they'd be reaching out to you, I'll be doing some outreach about the jail's ability to tend to Mr. Williams's health needs?
I don't. I can obviously reach out to whoever needs to be reached out to. I neglected to inform the court as well. The incident that occurred that defense counsel had referenced that Mr. Williams was out on bond for. It was an assault from July of this year. It was actually an assault on the same victim.
Mr. Clark?
Yes, and there are eyewitnesses who watched Mr. Williams out of nowhere begin to attack Mr. Clark as he sat on the porch and was defenseless at that point as well.
All right, thank you. Ms. ISL, I'll hear from you again. I forgot to ask Ms. Jackson from Pretrial Services about Mr. Williams's criminal history. It sounds like Ms. Jackson, Mr. Williams has some convictions. I'm curious how old they are, if they're from the 1990s or if they're from 2 years ago. What information do you have?
Okay, they're from the 90s, Your Honor. He has 18 cycles. The last arrest was July the 19th, 2000.
They're often, majority of them from the late 1990s. The most recent one is 2002. The terrorist threats out of the Cap County.
Okay. Ms. Nelson or Ms. Hansberry, can you call IT so we can figure out why we're not able to hear folks who have dialed in? It sounds like it's not just a probation issue. I mean, there's clearly something going on in the courtroom, but we weren't able to hear Ms. Jackson. Thank you.
Can you hear me now, Your Honor?
Ms. Iasello, I would like, with your client's permission, to be able to talk with the jail medical staff. They'll be more candid with me if Mr. Williams says, hey, you can talk to Judge McBurney about this. Yeah, that's me. I don't, this seems different, but because it's clear, like we see the little microphone is showing that it's receiving things, but it's not coming out of the podium. But you may be right. Oh, that's not working either. Okay, so it's just thank you. So.
Mr. Williams is fine with you contacting.
Okay, and Mr. Williams, I'm not trying to pry into your personal medical situation, but it's important that you get the care you need regardless of these charges. And I need to balance whether that can happen while you're in custody or if you need to be out on bond for that. So that's helpful, and I will reach out to the doctor who manages the healthcare at the jail. Was there anything, Ms. Iasello, you wanted to add or respond to?
Your Honor, I've not had the opportunity to review the ring footage, so I can't speak to the accuracy of of counsel's characterization of that. But I would submit that Mr. Williams was obviously in his home. He did not flee the scene. He is committed to fighting these charges and clearing his name, and I do believe he is a good candidate for bond.
Okay. Your entry is for bond. Is it as long as we're going back and forth about bond, or it was for today? Okay, all right. Mr. Williams, I'm not going to set a bond at this point. I need to talk with the doctor at the jail to better understand how the jail might be able to or might not be able to support your health needs. In the interim, I guess, I'm fine requiring the state to get the ring camera footage to you, even though you won't necessarily be the lawyer long-term. It's certainly helpful. They're not obligated to do that, but I often ask when the state is particularly reliant on something in a bond hearing to get that to the other side.
I would appreciate that, Your Honor.
Okay, great. Mr. Abate, would you be able to get to Ms. Iasello the ring? Oh, he's gone. Mr. Rao, would you be able to get the ring camera footage? I don't mean right now, but just in the next few days, get that across to Ms. Iasello.
Absolutely.
Is he coming back?
You should.
Okay. Did he have to go down to 1C?
I believe so.
Okay. It's that kind of day. Yeah. So do you have any questions about what I said, Mr. Williams?
He wants to ask a question.
Okay, what's your question, sir?
I see, if we got jail, they're not gonna, I mean, I already know that, because, the day up to this, my kidney, okay, she said that, that new thing show that, my kidneys were good, but I've been at a transplant, okay? All right, my brother gave me a kidney, and they do that. They just looking that for people, you know what I mean? They just gonna do that, yeah, for people like that.
Okay, well, that's what I'm gonna talk to them about. And are you on dialysis, or because you have a new kidney, you're not on dialysis?
See, I go back for vaccine at Tennessee. I go back for every 3 months.
Okay.
To be put on, they call that, extra dollars, okay? Like, you know, I don't build it like, you go out like that, build it like overnight.
Okay.
Out loud, you know.
Well, I'll talk with the doctor, and then I will certainly let your lawyer and the prosecutor know.
All right, we're going to Judge Whitaker's courtroom because they're not doing anything. So here we go. Please give me a 1 if you can hear.
Mr. McMullen, but we have the counsel for everybody else. So we'll just go ahead and get started with the final pleas for those people. Are there any guilty pleas that are going to be tendered today by any of the attorney, any of the defendants?
Yes, Your Honor.
All right, why don't y'all come on up to the podium, please? All right, Mr. Gotti, whenever you're ready.
For the record, this is
And everybody, I'm just gonna give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183-572, State of Georgia versus Mr. Miles Farley. Mr. Farley, if you'll please raise your right hand. You solemnly swear and affirm that testimony about the given the matters pending before this court will be the truth, the whole truth, nothing but the truth, sir? Yes, sir. Okay, put your hand down. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask you more questions. So choose if you want.
And Mr. Gotti, maybe reposition the mic while he's doing that.
Yes, Judge. Mr. Farley, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? And how far have you gone in school? I got a bachelor's degree. And are you able to
also speak into the mic, please?
26 and got a bachelor's degree.
And so are you able to read, write, and understand the English language?
Yes.
And do you understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate Rico, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm and the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial. Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to?
Yes.
And he advised that for count 1, Rico, the minimum is 5 years, the maximum is 20 years?
Yes.
And do you have any questions as it relates to that count, the single count that you'll be pleading guilty to?
No.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, but the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge. Yes. Do you have any questions about that?
No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else?
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir?
Yes.
Do you also understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights?
Yes.
And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that is in your best interest to do so?
Yes.
And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial?
Yes.
Okay. And how do you plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572?
Guilty on the Alfred.
And Mr. Farley, is this Alford guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to?
Yes.
And do you understand that you may have a limited right to appeal this guilty plea conviction?
Yes.
Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraints that you have to file under those areas of the law.
Yes.
Okay. Do you have any questions about that?
No.
Okay.
All right, and your attorney, Mr. Menendez, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am. And just for the record's clear, I just provided to Ms. Percival the indictment, which was signed by all parties as it relates to the defendant's guilty plea to count one conspiracy to commit Rico. Your Honor, has this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January
his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk
Here,
about
Yak
off the
is up,
record,
so
just
we
because of
flipped over here.
the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot, it's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. There'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place, and the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're going to be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Daryl Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Hansberry.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick. And
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang members' territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor, 15 SC 140116, and it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentences with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assault. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the 2 cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation, a bond hearing or a sentencing hearing. Is your best forecast, with maybe one exception?
That's correct.
Okay, all right.
Thank you, Judge.
Thank you. Ms. Bumpus, want to give you the last word. I'm gonna not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that, because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not 2 separate crimes.
Got it.
This 2015 is the federal
All
case.
right, so there just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge, so not two separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. It may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured, so I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these two cases.
And Your Honor, how am I gonna, can someone email me about the probation or?
I will keep everyone in the loop.
Okay, thank you,
Okay.
Judge.
All right, Mr. Rao, anything else from the state? All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to
So
give
we're
up
gonna
your
jump back
phone.
over to Paige
You get it
Whitaker's
back when you
courtroom,
leave.
where she's still got Mr. Farley up, I believe. Here we go. And I think they just recessed. Of course they did. Or they're going to the next person, maybe. Let me see. Did they just recess? Let me see what happened. Let's back it up. Oh, nope, they're going to the next person. Good timing.
And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right, thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right, not December though, not that soon. Okay, so have we covered everybody other than Mr. Minder at this point? Yes. All right, so let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
Statement of no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be.
Okay, well, there are 2 officers who got shot.
Well, actually, there's only one who got shot.
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
No, it is related to both, but the other witness is not necessarily important for the
Okay.
motion.
All right, so that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay, all right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent and how you're acting in self-defense.
I mean, if he wants, whoever he wants to call, he can call. And I get that. So do you think you'd be calling your client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client after discussion with him, and it may be a situation where we may the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at.
She just rubbed her nose. I just want to point that out.
Sometime the week of January 13th.
If it's just the video, the state would stipulate to the video coming in, Your Honor, making a.
Okay. All right. Did you, I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right, let's do 10 a.m. January 13th.
Your Honor, I did file a response
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in an abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay. Just making sure. All right. And then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want 1 witness, and it would be who we would need a production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Evans.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark. But okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of
Okay, I guess it's over. They are wild. She was in the middle of a sentence. Let me see if anybody. What in the world? What was that? Oh, it's over. Okay, well, they could have said, okay, we're wrapping it up now or something. Went to the seal. They just went, okay. Okay, well, shots fired across the bow from the prosecution on the side of Yak Gotti. He said, you want to know why this jail is so bad? Well, there's your reason right there. And points at Yak. What was that? That was awful. I couldn't believe he did that. That was so horrible to do. Let's see if I can find that real quick where he did that. I mean, that was unnecessary. I mean, I know you got to make, your defense or whatever, make your reasoning for why he shouldn't be out on bail, but that was too much. Way too much. Let's see if I can find it. What did y'all think about that? Wow, that was crazy. I can't find it right now, but I'll make a clip of it and make sure it gets up on the channel. Thank you guys for coming in and joining me. It's good to, it's actually good to see the seal again. Good old seal, good old Georgia State seal. Thank you guys. I hope y'all have a fantastic day. It was an odd ending. Yeah, it kind of just closed out. Usually they go back to the seal. But if y'all have any questions, please put them down in the comment section. I'll make sure they get addressed and make a video about it. Y'all have a fantastic day, and we will see you guys later. Grace and peace, everybody.
Hit that light for a deal, Christian. Yo, For deal Christian, smash that bell. For DWC, yo, smash it, just smash it. Hit that like for deal Christian. For deal Christian, smash that bell. For DWC, yo, smash it, just smash it. Hit that like for deal Christian.